But we did get an email over the break from Brandy, if we could put that up. My son was in a car with a friend. The friend went in the store and left my son and another boy in the car. My son thought it would be fun to drive. He is 14. He wrecked the car. The other guy's mother said that their estimated cost is $1,300 for repairs. I know that I'm responsible for helping with repairs, but how much should I cover? I was ready to pay the deductible, which is usually $500, but I don't have $1,300. What should I do? I need help. And that was from Brandy. Brandy, you're going to have a tough talk with the son.
Didn't something like this happen with you when you were a kid in Mariana?
Me?
Yeah.
Not with me.
Wasn't there something about having to drive a car that could only go forward?
I did have one like that. I did have a vehicle that until it was warmed up.
But that wasn't you?
That was not me.
That was not
That was not me. That was after 16.
I got you.
Yeah.
I got you. Well, yeah, you know,
I had many fun vehicles on the path to what led me here.
You know, that question is like, it's kind of like a law school exam, because I see so many different nuances in there. I mean, obviously the kid can't drive.
No.
Yeah, so, and parents are responsible for their kids, you know.
At that age.
At that age, the parents are going to be responsible for it.
Not forever.
Not forever, but you know, it may be something that may or may not be covered by your insurance, but if you do end up having to come out of pocket, there's a little bit of an argument that the person that owned the vehicle, leaving it unattended, leaving it with keys in the car, you know, there might be some responsibility on the part of the guy that left it in there. Now, a lot of people are thinking, well, that's not fair, I didn't do it. Well, you know, maybe. All that would do is potentially reduce kind of that percentage of liability.
But let's talk about the damage.
Right.
I mean, what the fact of what the deductible is and all that, from a damage perspective, is irrelevant. I hate to say it, Brandy, what your exposure is what those costs are to repair.
It's just whether or not there may be coverage to offset that exposure. But yeah, I mean, you could probably go round and round and point fingers, but that's one of those types of things, even though $1,300 is not an insignificant amount of money in the broad scheme of things, it's an insignificant amount of money when you factor in a lot of the other
He could have put it through that convenience store, and then
he could have gotten hurt. His friend could have got hurt. There's a lot of things. So sometimes you just got to go, whew.
A lot of lessons here.
And then you got a good story, you know, 20 years later, you know, when he's getting married.
Right.
But
Brandy, the son needs to be mowing some lawns and getting that money together to pay for that.
That's right.
But
I don't think they do that anymore. I think he needs to create some content. Is that what they do these days?
I mowed lawns, but many years ago.
Me too.
But what you did mention there, Les, is of some, I think we should discuss briefly, is this whole comparative fault issue. And you know, as we have discussed on the show before, we have had some fairly significant tort reform in the state of Florida. Whereas historically, Florida has been what was known as a pure comparative fault state, which meant you were entitled to recover even if you were just only slightly, if the other person was only slightly responsible, even 1% responsible, they would have to pay you 1% of your damages. But with the new revisions to Florida statutes now, if the defendant can establish that you, as the person making the claim, are more than 50% responsible for the accident, it's not that you only recover that percentage, whatever it is, 20, 30, 40%. You're actually completely barred now. And so that was a big shift and change, and can make certain types of cases more difficult to prosecute now, in particular your premises liability cases, where there's a lot of, there's a lot of, I don't know if you want to say it, hesitancy potentially on the part of juries on, you know, whether they're, you have that more in the slip and fall type cases where there is, unfortunately, been some history of some people having some fraudulent situations there. But it's just something we have to factor in the analysis now.
It is. You know, the slip and fall cases, the way the Florida law treats slipping and falling on some substance versus tripping and falling over a static object, law is completely different in the state of Florida. You know, it's been liability or charges of liability against premises owners have been slowly, you know, eroding the rights of the injured party over the years. It started out many years ago. There was a case involving a supermarket chain, and it went from, it used to be that if you slipped and fell, it was the store's responsibility to prove that, they didn't know about it, it wasn't there very long. Basically they had to prove that you were wrong. Now, if you slip and fall on something, you have the obligation of proving that the substance was on the floor for a long enough time and that the store should have known something and have done something about it. So it basically flipped the burden over to the plaintiff. Now, it's another step where they're saying, well, if you're more than 50% at fault, then you can't recover at all. And that's a situation where maybe you might have had equal knowledge of the hazard, maybe you didn't. There's a doctrine in premise liability called open and obvious. People talk about, well, you slipped on that. It was open and obvious. You should have been able to see this substance on the floor. These are all defenses that they can raise, and with a slip and fall case, the open and obvious defense it's a real defense, and people kind of look at it from a common sense standpoint. And I've always been amazed that, whenever you're looking at what somebody else did, people always say, well, I wouldn't have done that. Mm-hmm. But then you find yourself in the situation of, you just didn't see this, this water or this, juice or whatever on the ground, and you busted your tail, and now, but it really changes a lot of things. The other thing I noticed about the tort reform, the notice requirements and the shortening of the statute of limitations and the 51% compared to negligence, they talk about the limitations on what sorts of damages you can present to a jury, what you can, what you can't. I remember distinctly hearing, we get these changes in the law and our premiums are going to come down.
Just go right down.
They're going to go way down. I don't know about y'all, but my premiums have only increased ever since all these laws have gone on. So, I say that to say this. Educate yourself on what it is that a personal injury case involves, what it is that lawyers do to protect your rights. What you're always sold isn't necessarily the truth. But
Very well said.
There you
Very
go.
well said.